Okay. All right, it looks like we're ready to go.
Okay, thank you. Good morning.
Good morning, Your Honors.
Good morning. Welcome to the First District Court of Appeals. Thank you for joining us this morning. And we have one case set for argument this morning. The case number is C190462, and it's State versus Lawrence Sipple. If each counsel can please identify themselves and their readiness to proceed.
Laura Peters, on behalf of the appellant, Mr. Lawrence Sipple, and I am ready to proceed.
Good morning again.
Chris Brown, on behalf of the appellee of the City of Cincinnati, ready to proceed.
And good morning again. Attorney Peters, would you like to reserve time?
Yes, Your Honor, 3 minutes, please.
Okay, whenever you're ready.
Okay. May it please the court. Mr. Sipple's actions on May 8th, 2019 may have been ill-advised and in poor judgment, but we submit that it was not criminal. In this case, the state failed to prove that he acted secretly or surreptitiously or took a substantial step in attempting to video photograph Miss Chestnut under her garments to view those undergarments. So on that day, Miss Chestnut was in line at a park in a Lord's Gym event. She was waiting in line for food with a bunch of other people around when Mr. Sipple came up to her, nudged her, and whispered in her ear, "I hear you're freeballing." And she said that he kept trying to talk to her and that she was just blocking him out. And she does testify, especially point out to cross-examination, that she sees him pull his phone out, that the screen is blank, and then she says she felt it underneath her, she felt it underneath her dress because it touched her legs. She said she also says that the phone was still black, that she never heard him that there was any click or anything, and that he immediately was still laughing and joking, like nudging her, and that he walked away, and that he immediately told other people what he did. Now, what part of that constitutes acting secretly or surreptitiously? Officer Matthews testified that several people came up to him and saw what Mr. Lawrence did, what Mr. Sipple did. This was not a case. So he's drawing Miss Chestnut's attention to his presence. She's actually seeing a blank. We also have she says she saw a blank screen on his phone, but we don't have any testimony of what type of phone this is, what the capabilities of the phone are. We don't know if, because she saw the black screen going underneath her dress, whether or not that was even possible for him to photograph or video her with the blank screen up. Because we don't know what his cell phone, or if this was what his phone capabilities were. We also because this was an attempt, there was no proof that there was actually any video or photography taken. And we don't even know that there was.
Could it be argued that he took a substantial step to videotaping her?
Yeah, I'm arguing that there's no proof that he actually took a substantial step towards taking a picture or taking a video, because we don't know. Again, there was no evidence as to what the phone capabilities are. There was a blank screen. She didn't hear any click. She didn't hear, like that there was any attempt. In his words, and as he explained it to the officer, it was a joke. He was trying to, in his word, BS, as he's, admittedly, yes, this was in bad taste for him to do this. This was not, most people wouldn't consider this a joke, but it doesn't actually prove that he was actually attempting to take a video or take a picture, just that he was making a joke, because actually—
Isn't it enough that he put a cell phone underneath her dress? I mean, you're arguing that we need more information about the cell phone in order to find a substantial step. Is that what your argument is?
In part, yes.
So if we knew that the cell phone could take video or photographs, and he just put it under her dress, would that be enough?
No, because you actually have to, the state, because this was an attempt, has to show that he purposely was doing this to take a photo or a video. And there's no
Why-
evidence of his
why is it-
purpose.
I'm sorry, I apologize.
That's okay. Go ahead.
Why isn't it a reasonable inference that if somebody puts a phone that side up under somebody's dress, that the purpose is to take a picture or videotape? What other purpose would there be?
Now, as his purpose was, is that this was just a joke, because as he told the officer, he was aware that she would wear shorts under her dress. So that's what she normally wears dresses, and she always wears shorts on her dresses. So there was, based on his knowledge, what he told the officer, that he would know that he wasn't actually going to get a picture of her undergarments or view her see any undergarments under the dress.
But clearly the jury didn't believe him.
This was a bench
this-
trial.
Or I'm sorry, the judge, the
Mhm.
finder of fact didn't believe him. And so, I mean, we're just, granted, that's what he testified to, that what was in his head, but his actions, I thought we have to look at his actions to determine what a substantial step is. And he put a cell phone underneath her dress.
Well, he told the officer that he did not actually put the phone under her dress. But she said she felt it on her legs. We're not sure exactly where she felt it on her legs, but as
Isn't that again ultimately up to the trier of fact to make those determinations? So there's conflict in the evidence, and the trier of fact made a determination, and they determined the facts against the defendant.
But I think that the trier of fact was also, because she specifically continued the trial to review some of the testimony, and she seemed to believe that the witness that Ms. Chestnut didn't actually see the cell phone go under her dress. And actually, if you look at the cross-examination, she actually says it multiple times. She says multiple times, "I saw a black screen go under my dress." So what we know is that it was a black screen, but what we don't know, again, going back to the phone, we don't know if even from that side, whether or not that phone could have taken a video or taken a photograph. The officer didn't look at the phone. Ms. Chestnut doesn't describe the phone. And we also have the issue about whether or not this was secretly and surreptitiously done. If she sees him doing this, it's not secretly, it's not surreptitiously. Multiple people actually told the officer that they saw what happened. This is, again, not done secretly or surreptitiously. This is done out in an open park where people are waiting in line for food, that he's actually nudging her and talking to her and telling her about, "I hear you're freeballing." He's trying to make a joke. Again,
I
bad taste.
thought the record showed, and correct me if I'm wrong, that she actually testified that she wasn't aware that he had put the phone underneath her dress until after she felt it touch her legs.
That's what she testified to on direct, but on cross-examination, she does say on a couple of times that she saw the phone go under my dress. It was black. I believe that's, if you look at my brief, I know I have the pinpoint. I think it's like around page 12 to 14 of the transcript, where it's on cross-examination, where she actually does say, "I saw it go under, it was black."
Just because somebody sees someone doing something doesn't mean it's not being done secretly, does it? Just because you get caught doesn't mean that it wasn't trying to be done secretly.
Well, in the Middletown Reese case, that was part of the reason that they overturned that conviction, is because in that case, the cell phone was being dangled over a partition, and the screen was black. And that defendant was likewise convicted of attempted voyeurism, but the 12th district reversed because it was openly done. So I would say this is, again, similar. This is not done where she would expect ultimate privacy, that she wouldn't be in a position to be had video or photographs taken of her, she wasn't expecting to have other people around her. So his actions, again, with her, she's talking about, he's nudging her and he's talking to her. He's making his presence known to her. So
Maybe he's making his presence known to her so that he can serendipitously stick the phone under her dress.
but he's also calling attention to that, to the, saying, oh, I hear you're freeballing. He's referencing that area. He's not being secret about what he's doing. He's not immediately afterwards. She says he goes and he tells other people what he did and he's laughing about it. This was just a joke to him. And that's what, I would argue the manifest weight of the evidence shows is that this is a joke done in poor taste. But again, not something that really amounts to a purposeful attempt to secretly or surreptitiously take a video or photograph of her. Unless there's any other questions, I would probably just submit also on the second assignment of error unless there's questions on that one.
Thank you.
Thank you. We just ask that you reverse Mr. Sippel's conviction. Thank you.
Thank you, Attorney Peters. Attorney Brown?
May it please the court. I would like to start off by pointing out that in Middletown, the reason that 12th, I believe it's the 12th District Court of Appeals there, reversed that decision was because the trial court in that case specifically stated that he was convicting Mr. Rouse, I believe is how you pronounce it. I'm not quite sure how you pronounce the name, was convicting him because they believed he had the intent to violate the statute. They completely based their conviction in that case off of mere intent to violate the statute. And obviously you need more than an intent in order to violate a statute. In this case here, we have a substantial step towards committing voyeurism. He goes up to her, he does start nudging her. What he's doing is basically saying, watch my left hand while I do something else with the right hand. He's got her attention, and she does see him pull out the phone, but she specifically testifies that she didn't see him place it under her leg. When she became aware that the phone was under her dress was when it touched her leg. And I realize the phone, she says the phone was black. We never heard a snap or any other noise to indicate a video or a photograph was taken, but that's not required here because we're dealing with attempted voyeurism instead of voyeurism itself.
What about the argument that because there was no investigation done of his phone, of his device, and we don't know what capabilities it had, that kind of goes toward whether there could possibly be a substantial step if we don't know the phone could take video or photos?
What I would say in that situation that we have here is that with technology as it is today, pretty much every phone that someone has the capability of taking photo or video. It is not a gigantic leap in logic to assume that whatever phone he had was capable of at least taking a photograph. And I believe because we have a conviction here, that's clearly what the trial court did. And I believe
So we can just make an assumption that the phone was capable?
I believe it is obviously an assumption, but I think they could, yes. It's not if we were talking, maybe 10, 15 years ago, that would be a less logical step to take. But because of technology where it is today, where pretty much every cell phone on the market has the ability to take phone or video or photographs or video, I don't believe that's a big jump in logical reasoning to assume. And then you would also have to imagine why on earth would he place a phone underneath her that was incapable of doing that? He never acted like this was a joke towards what he was doing until after he was caught. That's when this thing became a humongous joke, and he started playing it off as one. He is not, someone who was a friend to her. She testified they merely were acquaintances. They barely knew each other during the trial. This isn't, what he was doing isn't something someone his position really has any right to do. Or even if he was, this is my best friend, you still don't have, you still can't place your phone in certain places. What he did was he took a substantial step towards the act, and he got caught doing it, so he tried to play it off as a joke. And I believe the trial court believed the state's version of events and found him guilty, and the trial court was in the best position to evaluate the evidence, evaluate the credibility of the witnesses, and make a decision based off that. And it was guilty of attempted voyeurism as opposed to just a straight up voyeurism.
It seems as if Ms. Peters' argument is basically because when he's placing the phone under her dress, it's black screen. I think her argument is trying to push it into like akin to someone putting a camera that is known to be defunct, and as a joke, pretends to be about to be videotaping using a defunct camera that everyone acknowledges is defunct.
I would say that is just because the screen was black, it's pretty easy to open up a camera or open up a phone. You can readily change it from black to working just, by moving your fingers a little bit. It's not something that's hard to do. And for all we know, because obviously we don't have the camera, we don't have the phone, we don't know if a picture or video was actually taken. For all we know, that could have happened. And it's something that's pretty easy to do, would be my response to that.
Didn't he
Thank you.
offer up his phone to the officer that investigated, and the officer chose not to investigate the phone?
That is correct, Your Honor. And I don't have an explanation for the court why he did that. Do I wish he would have? Yes, this would have made things much simpler. We probably wouldn't be in this situation if the officer had done that, but we have to deal with the evidence as we have it, not as we wish we would have it. And this is what we have, and I believe the trial court made the right finding in this case. And then I do want to just address the second assignment of error briefly. And I will just point out that in cases like the one we have, the judge did put on the sentencing sheet to register tier 1, register as a tier 1 sex offender. And based off the case law we have in the first district, which is Lewis and Embry, when that is done, when it's clear they're registered as a sex offender and the trial court forgets to place the registration duties and notifications onto the sentencing entry, then the proper remedy is to send it back to the trial court in order for them to cure that error. It's
But
only if,
she notified him at the sentencing of his duties, right?
yes, she did. She notified him of everything. It's just not included on the sentencing entry. And in instances like that, it's remanded to the trial court for them to cure that error. It's only if they forget to classify the defendant as any sort of tier sex offender that it's void and it gets disposed of, which we don't have here. So I believe the appropriate remedy in this case is to uphold the trial court's guilty finding of attempted voyeurism and then send it back to the trial court in order to cure the sentencing entry to put the duties and everything else that is required by the statute onto the sentencing entry.
And what impact, if any, does Henderson and Harper have on the second assignment of error?
So I apologize, Your Honor. I remember Halsey and Rayber. I'm not sure what Henderson is. I apologize for that. That's
Typically,
my fault.
it goes to the whole void and voidable for correcting sentences.
So I believe in this case, if I recall correctly, void is when it's completely wrong and cannot be corrected. Voidable means that it can be sent back to the trial court in order to be corrected. This is what we have is avoidable judgment, one that is capable of going back and being corrected. I understand in this case, the defendant has served his full period of incarceration, but he is still under the effect of that tier 1 sex offender registry. He is still registered right now as a tier 1 sex offender. I believe I provided a copy of that to the court as a part of the brief.
And it's also on direct appeal, is it not?
This is under direct appeal, yes. I believe although I will point out, I did point out as part of my brief that no one yet has asked the trial court to correct the entry at this point. So it is possible the court could rule that this is moot or it's not ripe for appeal at this point. I believe since we're already here, it would be best for the court just to rule on the matter, or we will just be here in a few months dealing with this issue again. But I do believe the correct thing to do in this case is to send it back to the trial court to be corrected.
Do we know what happened to the form notification that he apparently signed, and why isn't that a part of the record?
Your Honor, I wish I had an answer for the court for that. I did try and look into it, have not been able to find it. My thinking is it just must have been given to the clerk and was misplaced somewhere. I obviously don't have anything to support that notion, but I can't find it. I know one was done because I was there at the sentencing, but it's since disappeared for some reason, and I do not know the reason why.
If we did have that, would that satisfy all the requirements of the statute?
To be perfectly honest, I don't believe so. That doesn't count as a sentencing entry, and I believe it must be directly on the sentencing entry that the judge writes the sentence on in order to follow the statute.
But do you believe all of those duties have to be incorporated in a sentencing entry? That's a lot of duties. I mean, it's educational requirements, moving requirements, change of address requirements.
Based off my reading of the statute, I would say yes, although I realize it is onerous, it is a lot. Also, being classified as a sex offender is a humongous penalty. It's not something anyone wants on themselves. So if we want to put something like that on someone, we have to follow what the statute says. So I do believe this trial court does have to sit there and unfortunately write all of that out, as annoying and as long as it can take. It's what needs to be done to comply with the statute.
That would go on a judge's sheet?
It would go on, yeah, it would go on probably on the sentencing entry. So they have the front part of the judge's sheet, obviously in the back. I believe the back portion is where it needs to be placed in order to be sufficient. But I am not an expert on that area. I didn't look into that portion whole lot. I just know it has to be on the sentencing entry.
Well, it's just how the Hamilton County does their sentencing entries in municipal court. They handwrite things out on a judge's sheet. And so that goes to Judge Meyer's question that they have to write all that stuff out on a judge's sheet.
Yeah, I do know that they've had to do a lot of they've had to correct a lot of those entries because it's not on the proper area. I've seen that a lot in the trial court where we have to come back and either the defense or the prosecution has to be like, Judge, we need you to write this on here so we can actually do the appeal. Any further questions? Thank you for your time, Your Honors. I would just ask that you uphold the trial court's judgment of guilty on the attempted voyeurism and then send it back to correct the sentencing entry in regards to the sex offender registration duties.
Thank you, Attorney Brown. Attorney Peters.
Thank you, Your Honor. I would just like a little bit to the state's argument about the second assignment of error. In this case, what he's asked, I disagree that Mr. Sipple is still under the duty to register. The sentencing entry just says register tier 1. It doesn't have a duration. So he's not under a 15-year duration period because the sentencing entry, which is what sets the sentence, only says register tier 1. And that he had to serve 3 more days in jail. Mr. Sipple.
But aren't the tier 1 registrations automatic and mandatory as a matter of law, so that there's no question about what that is?
But it has to be included in the sentence. And that is clear. That this court has said that in Hildebrand, that the duration, the registration classification have to be in the sentencing entry. The duration is not in the sentencing entry. So once he registered once, I would submit that he completed that sentence. He's completed the jail term. This is a completed sentence, and the state didn't appeal to correct the misstatement in the sentencing entry that for the failure to require him to register for 15 years. So we would argue that that since he's completed the sentence, that it is final, and that because the state didn't appeal, his sentence for that purposes should be considered final, and that we are just asking this court to vacate that part to make it clear that he's no longer has to register because he was never properly registered. He was never properly sentenced to register.
But
for 15 years.
the judge at sentencing told him 15 years, right?
Yes, I will. Yes, I will
And so,
acknowledge that.
and she told him all of his obligations. So it just
Yes.
didn't make it onto the judge's sentencing form.
But the court speaks through its journal entry, and the journal entry here does not contain the duties or the summaries the summary of his duties, nor does it contain the duration of his years to register.
So that's not
So-
something we can correct, we can have the judge correct, because she did pronounce sentence. It just didn't make it onto the written entry.
Based on the other case that I cited in my brief, that it's too late now to do that non-protunct. Could there have been a non-protunct? Yes, if she had done it within the 3 days that he was, or before he had registered, I would say yes, but once the sentence is completed, it cannot be changed or corrected. So we're arguing that he should no longer be under the obligation to register as a sex offender. Now, with regard to his conviction, of course, this would be all moot if you would find that, and as we submit, that he did not act secretly or surreptitiously. Again, Mr. Brown's seemed to indicate that this only became a joke after he got caught, but that's not true. That's not what she testified to. She testified he was laughing throughout this and nudging her, laughing. So to Mr. Sipple, this was always a joke. Obviously, I agree to Ms. Chestnut, this was not a joke, but it didn't make it criminal because it doesn't express his intent. And again, I urge you to look at the cross-examination where she does say, I saw the phone go under. I think it's on page 13 and 14 that I have, that she does say, I saw the black screen go under. Again, there's too many inferences that have to be made with regard to the phone to know whether or not he actually did take a substantial step to photograph or video her, because we don't know that this is a smartphone. She said the screen is blank. What is this, just a small screen from a flip phone? I don't know, because I don't know what the phone is. There was no testimony. The officer refused to look at the phone. She doesn't and Ms. Chestnut doesn't describe the phone. So we don't know if this had a camera that could go with, whether it had the most updated camera or cell phone that this is, or that it could take a photograph from either side. We don't know. There's too many inferences that have to be built on that to actually show that he took a substantial step to photograph or video her.
But your argument that it was a joke, his joke was, ha ha ha, I'm going to take a picture of you under your dress, right? So,
No,
I mean, well, then what was the joke?
the joke is just because he was just joking with her that this was, oh, I hear you're freeballing, when he knows that she doesn't do that and that she always wears shorts under her dress. So this is just, again, a very very bad taste joke that he was trying to play, like, oh, I'm going to act like I'm doing this. But he knows it's not going to happen because he knows that she wears shorts under her dress, and she testified, I always wear shorts underneath my dress. And it's apparently something that's known. And we also don't know that he actually attempted to take a photo because, again, black screen, and there was no audio. You didn't hear a click. And it's, like she says he went away and went and told other people what he did. But she doesn't say that he showed him his phone. Like, look at I tried to take this phone. He was just making a joke. And so we would ask that this court would reverse his conviction and discharge Mr. Sipple. Unless there's any other questions, I'll submit.
Thank you for both of your arguments this morning. We will take the matter under submission, issue you a timely decision, and we wish you a wonderful afternoon.
Thank you.
Thank you, Your Honors. Have a good day.
Thank you.